Well, here we are, another Monday, and you know what that means, right? Yep, it's another video on taxes and estate planning. However, in the spirit of the impending holiday season, we're going to talk gift taxes today, but probably not in the way you think. Let's talk gift taxes, generational wealth, and when your estate plan gets crummy. But first, please be sure to drop a few crumbs and like the video, subscribe to see more, and ring the bell to stay up to date. As always, thank you for watching. Let's start at the beginning. Have you ever thought about gifting money to your loved ones, but were concerned about taxes or how they'd handle it? Well, there's a trust for that, or at least a provision you can put in your trust, aptly named after a court case involving a family named Crummey. Crummey v. CIR. But before we dive into Crummey trusts and what they have to do with gifting, we need to understand trusts in general. Picture a trust like a safety deposit box. You, the creator or settlor, place assets inside, and a trusted individual known as the trustee manages them. Over time, these assets can be distributed to people you designate, known as beneficiaries. Let's break things down and learn how a Crummey trust is unique. It's all about giving gifts in a tax-efficient way. As you are likely aware, there is a gift tax for gifts given over a certain value, which is currently anything over $17,000 per year per recipient. This is an amount you can give without tax consequences. As a quick note, there is a lifetime gift tax exclusion limit, but we're not going to talk about that today, since Crummey trusts typically operate to stay within the yearly gift tax exclusion limit, $17,000. Now, most of us have heard about this in some respect, and that's typically where the analysis ends. But there's a catch. To qualify for this exclusion, the gift must be of present interest. In simple terms, the recipient should have immediate access to it. This is where Crummey powers come in. They give beneficiaries the right to withdraw gifts for a short period of time. If you're a little confused as to what I'm getting at, allow me to break it down into plain English before we get into the weeds. If you want to be able to gift money to someone, not trigger a gift tax, allow for the recipient to not have to take the money, yet still set the money aside for them, then you gift the money to a trust, allow the recipient to take the money for a short time, and if they don't, then the money remains in trust and we never trigger a gift tax. Whenever a gift is made to the trust, a Crummey notice is sent to beneficiaries. It's like a golden ticket telling them they have a short window, say 30 to 60 days, to withdraw their share. Even if they don't withdraw it, the mere option to do so qualifies the gift for that $17,000 exclusion. With that, you've set aside money for their benefit, allowed them the option to access it now for a short window, and have successfully separated the funds from your estate, all without causing a taxable event. Now, I know what you're probably thinking. Andrew, what's the whole point of this process? It sounds like just a more complicated way to give my kids money. Yes, well, it is a more complicated way to go about gifting money to someone, but the complexity is part of the point. What I'm getting at is, the point is to take the money out of your estate and control, set it aside for typically a family member, and not have to worry about pesky gift or estate taxes because, one, we stayed under the annual exclusion limit of $17,000 per person, and two, the funds are no longer part of your estate, thus we can help lower your estate value and keep you under the estate tax threshold. Additionally, the trust in question is going to be an irrevocable trust to allow for this separation. Yes, that means there's no going back on the contribution or gift, but that separation has its own benefits to consider. Now, if I get sued or have creditors, they can't reach what I've already given to the trust or family member. Additionally, if the recipient elects not to withdraw the money in the allotted time, then those funds are wholly separate from them as well, meaning no judgment or creditor access so long as those funds are in trust. Now, yes, the recipient will have the option to withdraw the funds in the period provided, and they would be fully within their rights to do so, but this sort of structure and planning will often come with an understanding of the intent behind those involved. Additionally, between you and me, when someone, say a child, who chooses to exercise their ability to withdraw the funds when allowed, the parent can always elect to not make a contribution the next year and perhaps play it by year for each year thereafter. As I've hinted at before, there are some points to keep in mind if a Crummey trust is something you might be interested in. They do require some administration, like sending notices to the recipient beneficiaries in order to be effective. Also, the beneficiary can actually withdraw the gift in that allotted time. Additionally, once assets are in the irrevocable trust, you generally can't get them back. A principal aspect of all this is that degree of separation between the people and the trust. Today, we've unveiled the mystery behind Crummey trusts. While they're a powerful tool, they're not for everyone. It's essential to understand your goals and work with professionals to navigate the process. I'm attorney Andrew Bethel, guiding you to make the best. Drop a comment below if you have any questions, and don't forget to subscribe and check out our other great videos. Stay informed, and I'll see you next time. How did you get in here?